Well, answering to this, thank you so much. I definitely take your point that I'm still very much in the descriptive stage. With regard to your last point that it might be worth, or it should definitely be interesting to look at how the victims make use of these multiple avenues. I tried to give you the information I found so far, especially you can see where they file their claims, even though unfortunately the statistics are not one central statistic, but each institution has different statistics, so it's not so easy to find out, for example, who actually makes use of more than one avenue. So that's, I haven't found a way to really look into this, which might be interesting. And another problem which I have with this topic, even though I've been working on it for a while, I haven't put it into a finalized paper, and I feel I can't do it so far because it's so hard to find out whether the results actually, or how the results compare between the court avenue and the settlement in the center. And one reason is that there's no case where both avenues have been taken until the end. The settlements do not give reasonings. Few of them are published, so it's very hard to compare. I've analyzed one court case in another article which was a bit strange case where somebody killed herself as a consequence of desperation of the loss of their home, which had been contaminated, and the court granted her damages and applied a comparatively generous approach to contributory damages in this case. And I hope I will be able to see in the future whether this generous approach is also adopted in the center, but I haven't been able to spot it yet.
Thanks, Ido. I think you're making a very good point. Basically, as far as the British are concerned, as they said, they decided not to intervene. It's a bit strange. They kind of, between 39 and 45, the Jews in Palestine, or most of them, are allies of the British, so that would make sense for them not to intervene. Post 45, actually, there's a Jewish revolt with involving terrorism and stuff, and people collect money to finance basically some of, buying arms for Jewish terror. And I couldn't find any reference to the system. I think that's related to the fact that the British state is weak. This is a colonial state, and if they can't deal with the terrorism, it's even less clear that they can deal with fundraising. As far as evaders who complain, Jewish evaders who complain about being pressurized by, I found some kind of references to when there was use of violence, people complained to the police, and then the people running the system basically apologized, saying these are hot-headed youth who have, broken your windows and overturned the tables of Café Zitza in Dizengoff Center or stuff like that. And they were aware of the fact that actually you can see that there were some lawyers involved with the system wrote memos saying that we shouldn't formalize the system and have courts because then there would be a danger of us being accused of extortion based on the criminal code ordinance, based on the British criminal law. But apparently, very few people did complain. I found very few. You have the records you do have a very detailed records of the system in the archive, and that wasn't a major issue, kind of people complaining about the system. It was a very small, relatively cohesive community with a long tradition going back to the diaspora of not going to the Gentile government and, trying to undermine Jewish collective government. So I think that was partly the reason why the system existed in the first place and why you see less of an interaction of evaders with the governmental tax system, governmental criminal system.
So for people would like to ask questions, so we'll take two at a time, okay?
I'm still fascinated by both of your topics, and I would like to take the opportunity to draw our attention to a certain aspect. This morning we agreed upon that we are interested in the ways of changing or modifications of juridical systems of decision-making or legal pluralism. And with regard to the mass torts, we could get the impression that here it is an external factor, the massive natural catastrophe who produces the challenge which has been reacted to. With the tax example, maybe I missed it, but I don't think you mentioned it. Could it be that it's also an economic aspect of effectiveness? While you're building up a state, you might rely on structures who you can afford. I don't say this to justify the yakis, but to put it straight, the rule of law is something you have to be able to afford. And if you do so as a state, maybe then you establish another system. You modify or change the existing system, for example, by professionalizing.
Okay. So Moritz and Moritz.
I enjoyed both talks very much, and I learned a lot from the taxation example, which I find is wonderful because I always thought tax, that's the original thing that the state does and will never pass up. And it's interesting for me that the British didn't intervene actually. What it shows to me is one of the core problems of overlapping jurisdictions though, and that's the control of it. Basically, what do you do if you're on the list of the people who haven't paid? If it happened in the state, then in a regular system, rule of law system, you'd have a court, and then the court would test whether that's too much of an infringement, whether it's passing some kind of a balancing of interest test, things like that. If it's an alternative private system, then all you have is, and in most jurisdictions you don't have that, some kind of a protection of your reputation, personality right, something like that. So it's extremely diffuse, and you don't have any, or basically what you have is the entire system turned around, because the state has to justify that it's infringing rights, while a private person can just go ahead being as arbitrarily as it can potentially be. And so I think that leads us to something we haven't really discussed so far, which are the consequences, really, also the downsides maybe of having two different systems parallel to each other. And that's so interesting for me too, that the British let them do this, because in a way they were diminishing their own power over their constituents.
Is that the downside of parallel systems, or is it the downside of non-state law? Because I think what you're saying is it's just the downside. You're saying we like state law because it has all these protections for individual rights.
Absolutely.
Which non-state law does not.
Absolutely, but you have the same instrument that state and non-state law can both use for the same purposes. It does make sense to consider that maybe it makes sense that the state should not let that go into the non-state arena. You're absolutely right.
Moritz, maybe?
Well, regarding Guido's comment, yes, it was triggered by the disaster. I wouldn't call it a natural disaster in this case, or it's at least that's a controversial aspect to what extent it was a natural. With regard to Indra's comment, I would agree with David that this, for example, does not really apply to the Japanese example, because both avenues are in the end state avenues. If you would be cheated by the center, you could probably go for state liability or something, because at least I would assume. So it might rather not related to court against out of court, but or private, but rather private or public.
And I would just say that obviously when you talk about legal pluralism, there are pluses and minuses, pros and cons, and it's obvious that, you know, one of the good things about the state, for example, only the state taxing, is that there's protection of individual rights, there's certainty. Problem with these local committees, I would assume, would have been that kind of, there was a lot of favoritism, and also with this voluntary system, it was obvious that kind of, you know, some people felt that they were overtaxed and kind of couldn't, there was no recourse to any kind of formal norm that they could rely on. In the 1940s, the Jews basically didn't have a choice. They didn't have, they couldn't, you know, they didn't have their own police force, and they were afraid that if the system would become too formal, then the British might intervene. But they also kind of, I think they saw the plus was that they actually, there's more commitment. If you pay based only on social norms, you show, you signal a commitment which you don't signal if you pay based on coercion, and they're actually very keen to do it. And I think, you know, again, given the fact that it was a small cohesive community, I think it was that's the reason it was successful, and that's something that you cannot do once you have a larger community, and you run the state rather than being a minority community within it. So I hope I answered both questions.
Okay, so we have 5 people who want to ask in 10 minutes, so I'll just collect all the questions, okay, and then okay, so.
Just a question for my better understanding of the legal framework.
Right.
This tax system. Can you describe the legal status of this local Jewish communities? Were they municipalities in the sense of a modern common law? Did a written common law exist in Palestine?
I'll be quick. First of all, thanks a lot. It was very interesting. Actually, your studies, I think, really corresponds or correlates with one of our PhD candidates, Inbal Blau, which is also David's student, and she also studies mass torts cases in the history of Israel, starting from the 50s, if I'm correct, until the late 80s and the early 90s. And she also tries to bring, I hope I quote her right, she also tries to bring also some social perspectives into her study, and to show whether we can identify some kind of reactions or interactions between social dynamics within the Israeli society and tort laws, cases, real cases in Israeli history. And I'm wondering whether, when you study the Japanese cases, whether you can find some, if you are looking for this kind of social perspectives or social historical issues, because I'm wondering, and I'm seems like an interesting case, because both the tsunami and the nuclear issues in Japan has traumatic influences. But I think, and I'm wondering whether the special traumatic experience of Japan during World War II with the nuclear in Hiroshima and Nagasaki has something to do with this kind of a special treat, if we can say that, about with the Japanese state or the Japanese mass tort law in this manner. And to Assaf also a short question: if you are looking on this on your study on the non-formal taxation as a part, if I got you right, as a part from the Jewish or the Zionist nation building or building of the nation, so you can. Did you find some kind of a correlate or similar moves also within the Palestinian national movement, which also has of course this kind of a problematic situation with the Jewish issue?
Thank you. I'd like to comment on the first presentation. Hearing it made me think about maybe similar mechanisms that we don't associate that much with dispute resolution, but more with transitional justice, like commissions of inquiry and public commissions. And these types of mechanisms, in some cases, for instance, the one in Canada, not exactly in transitional justice, but the compensation offered to indigenous people that were transferred to boarding schools where they've been harassed or abused. Examples like this. So there are differences and similarities between these mechanisms, and you pointed out that the responsibility of the Japanese government, maybe for not regulating or for regulation deficiencies, is not being discussed that much in that in those dispute resolution mechanisms. Perhaps these kinds of mechanisms that I'm talking about discuss more state responsibility or state agents' responsibility and not other private sector responsibilities.
I would like to kind of ask whether we should provide an analytical distinction between the creation of a separate jurisdiction and delegation of powers by the state. That is, in the case of I think that it applies to dispute resolution as well, but in the case of taxation, following up on both of your remarks, so in a way the state, even though the state really functioning in tax collection, often delegated tax collection powers to farmers, to corporations, to churches, or whatever. And this could also be a solution under conditions in which the state could not afford operating a full-scale administrative collection mechanism. So an alternative, at least in the early stages of the days of the State of Israel, could be state-delegated collection rather than a communal collection.
To Assaf, regarding this communal tax system, if there were people exempted from this tax paying, officially exempted from this system, and because I wonder if there are, so maybe regarding this issue, maybe some complaints can get out of this communal system to the other state authorities about who can be exempted or not exempted, and questions like this.
I try to be short. First, with regard to the connection between Hiroshima and Fukushima, and whether this has implications for setting up this special center, if I got your question correctly, I think there's no connection. The substantive rules for nuclear liability in Japan are more or less in conformity with international standards. Japan is not has not been a member or a member state, didn't sign these conventions, but they basically conform to them. They even provided for unlimited liability, going beyond the global standards. Also, even one might be inclined to think that a nation who has just suffered an atomic bomb, or two actually, should be much more anxious about nuclear energy. This has not been the case so far, unfortunately. My easy answer would be no. As regards what I said about blurring responsibilities, what I wanted to say is that these compensation schemes outside the courts may be used or tend to, in order to blur or tend to blur responsibilities. I wouldn't say they always do, and sometimes it may be exactly the opposite, that the state actively assumes responsibility. I think with regard to German war crimes also, you might make the same argument. But it also offers the option to avoid this. And the most recent example from Japanese context would be that with regard to the forced prostitutes in the Second World War, Japan has now agreed for a very low amount of compensation in the fund, and the Koreans have accepted this because it was finally the Japanese state who said, we set it up. We don't just collect private money, but we set it up. But the amount is more or less ridiculous, and whether this is a clear assumption of responsibility or not is very controversial.
So regarding Peter's question about the status of the Jewish community, so local communities were recognized and they had the right to raise, the British allowed them to raise money for religious purposes, very low amount. There was also British recognition, British colonial recognition of the whole Jewish community of Palestine. He set up basically it was an election system, and it was basically Jewish national government. It was called the LOEWE. But the British didn't allow them to raise money in the way they did. They didn't allow them to raise, to impose an income tax in addition to the one that the British imposed beginning in the early 1940s. And Jews basically kind of just did on their own without any authorization from the British government. One was question about similar mechanisms within the Palestinian National. Actually, there were. Kind of 1936, they kind of, in order to fund the Arab revolt, they kind of started. It was an attempt to raise money both locally and also to raise money nationally, but the revolt is crushed by the British, so there's no continuity in the sense that we have in a Jewish community. Because basically the leadership is killed or exiled. There's also internal infighting. It deteriorates by 1939. So there's something similar. I don't think it was as sophisticated as what the Jews did. There was something. Tax farming is actually kind of the Ottomans. There was tax farming in the Ottoman Empire until the demise of the empire, which is really interesting, until the 20th century. And so Ottomanists really like to say that this is an example of the Ottoman Empire being the first example of privatization. We were the first. Ottomanists have this kind of inferiority complex regarding the modernity of the empire. I should say it.
He might tell here.
Somebody called Salzman wrote an article about tax farming as an example of early privatization. But the British didn't. They abolished it. Kind of, they took over the Ottoman system. They immediately abolished tax farming, and the Jews didn't think it wasn't in the kind of intellectual genes to kind of administrative genes to think about it. So you don't see something like that in the 1950s. There was no return to tax farming. But there was tax farming here until 1950. And Leo's questions about exemptions. I think exemptions are part of, you have exemptions once you have a kind of universal law that you have to be, you have to exempt somebody, so you create a provision exempt. So certainly individual exemptions. People send letters saying, I can't pay this, so exempt me. Rabbi Uziel, the chief rabbi of Palestine, chief Sephardi rabbi, you know, in the archive you see a long series of letters that he writes. He's asked to pay, I don't know, £5 this year, and he says, no, I just renovated the house, please exempt me, and kind of, he's a chief rabbi, he's a very important religious, but also political figure, and doesn't want to pay. So there's a back and forth, and ultimately he doesn't pay, but maybe he does pay. There's a long, it's all done individually, it's not done on a kind of collective basis, because actually there are no rules, there are no kind of written rules which determine that everybody should pay. It's just kind of.
But there was no kind of thought about people who are contributing to the Zionist project in other ways.
But
so there
like
are.
They didn't. I don't think kind of a lot of the money went to finance the families of people who volunteered to the Jewish Brigade, which served in the British Army during the Second World War. So I don't think these people, paid. They kind of something it wasn't deducted out of the salary, because that's something that the British would do. But I don't think they were asked to, pay, because actually the money was used to kind of assist the families that were left in Palestine while they went to fight in the Western Desert and later in Europe. But that's the kind of exemptions.
And it was a legal committee. I mean, the guys who decided where money is going to go. It was legal or political?
No, it was there was a presidium of the Mobilization and Rescue Fund, which was a committee of business people doing this on a voluntary basis. These were bankers, and they basically decided there was no non-promulgating body which was separate from the administration. There was a large bureaucracy, that's true. There was a bureaucracy, but there wasn't a separate norm-making body that one could identify.